Good morning, good afternoon, or good evening, depending on where you are in the world today, and welcome to Finnegan's webcast, the PTAB, Lessons Learned and Practical Tips. I'm Gary Ma, Resident Managing Partner of Finnegan's Taipei, Taiwan office, and I'll be your moderator today. It's my pleasure to welcome our presenters, Rachel Emsley and Jason Stack. Rachel is an attorney based in our Boston, Massachusetts office and focuses her practice on district court litigation, PTAB trials, Federal Circuit appeals, and client counseling. She has handled over 50 PTAB proceedings, including inter-party reviews, or otherwise known as IPRs, and covered business method reviews, otherwise known as CBMs. Rachel co-chairs the Boston Patent Law Association's Contested Matters Committee, which focuses on PTAB trials, and recently co-authored a book chapter on evidence in PTAB trials. With her background in electrical engineering, Rachel often represents clients in cases involving technologies related to computers, software, medical devices, electronics, business methods, and robotics. Jason is an attorney based in our Atlanta, Georgia office and leads Finnegan's PTAB trials practice. Jason has handled more than 100 PTAB trials, including IPRs, CBMs, and PGRs. He also represents clients before the U.S. Court of Appeals for the Federal Circuit in appeals stemming from PTAB decisions. He is on the board of directors for the PTAB Bar Association. In addition to his PTAB practice, Jason is also an experienced patent litigator, representing clients in the district court and ITC. Jason handles cases involving many different technologies, including electrical, computer, software, chemical, pharmaceutical, medical device, and mechanical technologies. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. Just click on the red Q&A button at the lower center of the webcast interface and type your question into the Q&A window, then click Submit. We will get to as many questions as we can during the question and answer session, which will take place at the conclusion of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. The slides will advance automatically throughout the event. If you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. And now I will turn things over to Rachel and Jason to begin our presentation today. The PTAB, Lessons Learned and Practical Tips. Welcome, Rachel and Jason. The floor is yours.
Thanks very much, Gary. This is Jason Stack. Thanks for joining us, everyone. Today, we're going to go through a number of different things, but one of the first things we're going to talk about is how the PTAB has changed. And in the 6 years that PTAB trials have existed, we've seen a number of different changes to the rules. Now you can submit testimony with preliminary responses, for example. We've seen changes from the courts recently, even the Supreme Court in the SAS decision, for example, in oil states. We've also seen some changes just by changes in leadership, with Director Iancu now wanting to make sure that PTAB trials at least appear and maybe are more balanced between patent owners and petitioners. So we're not going to dwell so much on the history today, but I do think it is interesting to look, if we look on the slide 4 here, to look at the cumulative effect that all of these changes have had on the PTAB. And one of the ways to look at it is from this data from the Patent Office on institution rates. We can see that in 2018 so far, they have instituted in only about 60% of the cases that they've heard. So it used to be a much higher institution rate. Things had stabilized in the mid to upper 60% range, 68, 67%, but now we're down to 60%. And I think that there are a number of reasons for that. Some of them are rules changes and changes imposed by the court. Others are just the political forces. Some of the changes are workload related, I think. When the PTAB now under SAS has to institute on all claims and all grounds, I think there may be looking a little bit harder at petitions and deciding not to institute some that they maybe would have instituted a few years ago. So it's interesting to see what the effect of those decisions has been. And if we look at the next slide, this data is also from the Patent Office. They call this their waterfall slide. And it has a lot of information, but what I want to focus you on is this here, the instituted claims unpatentable. This is a cumulative number, and in only 19% of PTAB trials has every claim gotten out unscathed. So they record it here as no claim is unpatentable in only about 19% of the cases. In 81% of the cases, at least some of the claims are being canceled by the PTAB, and in the majority, 64%, all of the claims are being canceled by the PTAB. And we can slice that data a little bit differently. We have an internal data set at Finnegan where we track every final written decision from the PTAB, and we report that data on our AIA blog. This actually is not on there yet. We're giving you a sort of a sneak peek of what is about to be posted to the AIA blog. And if you're interested in seeing stats like this, you can go to aiablog.com and put your email address in, and then you'll get updated stats each month. And we usually only send 2 or 3 emails a month with information, so we try not to overwhelm you. But you can see that over time, this is the survival rate of claims after a case has been instituted. So if the PTAB institutes, about 25% of the claims that have been instituted on actually survive the PTAB's review. And we can see that we say in the title here, survival rate is increasing, and that's true with the cumulative line that we see, the red line in the slide. But we see actually from 2017 to 2018, the survival rate has actually dropped somewhat. And that may be an interplay with the fact that they're looking harder at which petitions to institute. And so they're instituting fewer cases, as we saw on a prior slide, but once instituted, they're more likely to actually cancel the claims in 2018 than they were back in 2017. So I think it's interesting to slice the data up this way. And then one other thing I wanted to show you is the claim survival rate on a month-to-month basis. And it's kind of astonishing to me the way the survival rate bounces around month to month. You can see that in some months, over half of the claims survive at the PTAB, and in other months, less than 10% do. And it just gives you an idea of just how variable this practice can be. And there's a lot of variability both in terms of the statistics that we see, but there's also variability from panel to panel sometimes depending on which judges you get. And it's important to know that going into PTAB trials. And if you've done a lot of PTAB work, I'm sure you already have seen some of that. So those are just some of the history through some numbers here. Now we're going to focus more on some recent updates that hopefully you can use to further improve your PTAB practice. And I'm going to turn it over to Rachel Emsley to talk about those.
Thank you, Jason. I appreciate that. So as you saw, the numbers are definitely changing at the PTAB over time. Also, what we're going to talk about now is how some of the rules and practice at the PTAB have changed over the course of the AIA trial since 2012. There's been several ways that the practice has changed. The board has been issuing new standard operating procedures, new precedential decisions, and updating the CFR, the Code of Federal Regulations, where we find the rules for practice at the board. Another way that things are changing that we wanted to highlight is in the trial practice guide. And this is part of the Federal Register. There was a major update in August of 2018, and I wanted to point out a few highlights from this change to the trial practice guide. Much of what's in there, it's a fairly thick release of rules, but a lot of it is what is already reflected in the CFR, the rules that are applicable at the board. But some changes were to reflect current practice at the board and others are specific in the trial practice guide, and it's perhaps the only place where you'll find this guidance. So two of the things that we wanted to highlight today are that would have the most strategic impact, at least from our perspective, are the beginning of what's being referred to as a pre-hearing conference, and also a change that patent owners are now going to be allowed SIR replies in the substantive briefing. So looking at the first one with the pre-hearing conference, this is a new practice at the board, and in fact, we haven't seen many of these actually occur yet since August. These will only affect cases that are approaching the time for their oral hearing, so at the very late stage of the case. In the old practice, before this release in August, there was really no substantive guidance from the board after the institution decision and before the ultimate oral hearing. And now, what they are suggesting that we do is approach the board jointly, hopefully, but at either party's request, you can ask for a pre-hearing conference. So this is an extra hearing with the board that would occur no later than 3 days prior to the actual oral hearing. That's the culmination of the proceeding. And they've said that the purpose of this pre-hearing conference is to review, but not to argue, the issues that will be discussed at the oral hearing, to seek the board's guidance as to what issues the panel would like to see addressed at the oral hearing, to discuss pending motions to strike. For example, these would be of new arguments that are seen in the petitioner's replies or in the SIR replies, or to request an early decision on the admissibility of a limited number of exhibits. So towards the end of these PTAB trials, there's evidentiary briefing to hopefully exclude some of the evidence and narrow down the issues for the board. And before this practice of pre-hearing conferences, you would not actually get any ruling on an evidentiary issue prior to the final written decision in the case. So in this pre-hearing conference, there's the possibility that you may be able to get some of the issues narrowed down before your oral hearing, hopefully save some preparation time and expense of the parties. Before this practice, it's been very hard to prepare everything because you need to walk into that oral hearing not knowing whether a piece of evidence is in or out, having to argue both ways, whether there's a new argument that you would like stricken from the record as opposed to addressing that new argument. And before, we had to walk in arguing either way with respect to those arguments. And now we're hoping to see that the board will narrow the issues for us before we walk into oral hearing. They also did say that they, again, we have not seen these pre-hearing conferences happen in large numbers yet, so it's unclear exactly how this practice will play out at the board. But what we're hoping as practitioners and as stakeholders is that they would rule on these sorts of things so that we can narrow the issues. But they did reserve the right in the trial practice guide to defer those issues to oral hearing or to the final written decision. The second major change that was announced in the trial practice guide in August is that during principal briefing, so with the what starts with the petition, and then there's the preliminary response, and then institution of trial. After institution, we saw only the patent owner response and the reply previously in these cases. And now what there will be is a petitioner reply, and now there will be a patent owner's SIR reply following the petitioner's reply in the principal briefing. This is a major change because what happened before, under the old regime, before this trial practice guide change, was that if there was any new deposition testimony submitted with the reply, new expert testimony with the reply, with the petitioner's reply, the patent owner's only opportunity was to depose that expert and then make some observations for the board to enter what we called an observations on cross-examination. These were very limited. They were not supposed to be an argumentative SIR reply, but rather a short sentence in explaining the relevance of some cross-examination of a reply witness. And now the patent owner will be allowed a full-fledged brief. Still, this has to be limited to the evidence that's already in the record. So you can submit deposition transcripts of cross-examination, but not new evidence. And you still have to only respond to arguments made in the reply briefs. It's a responsive brief. You can comment on the reply, declaration, testimony, or point to the cross-examination testimony, but you're no longer limited to these short sentences just pointing out observations. Outside of the trial practice guide changes, we've seen a major shift. I think this is one that many of you are interested in. The board announced that with a comment period, they announced that the claim construction standard would change from the broadest reasonable interpretation to what we refer to as the Phillips standard. And now this change is effective quite notably today or yesterday if you are in other parts of the world. It's effective on petitions filed on or after November 13th, 2018. This change is, again, from the broadest reasonable interpretation, which was a unique way of construing claims in the Patent Office. This interpretation is the one that examiners use during prosecution. It's the historical interpretation that the office has used during reexamination procedures, and the one that has been going on at the board now since AIA trials began. However, they have been using the Phillips interpretation to construe claims in cases where the patent has expired when the petition is filed. The Phillips interpretation is the one that the district courts and the ITC has been applying. And so it's helpful, I think, to review just very quickly what the difference between these standards might be. Under the Phillips construction, a claim has the meaning that the term would have to a person of ordinary skill in the art at the time of the invention. And this construction is supposed to be affected primarily by the intrinsic evidence, meaning the claims, the specification, the prosecution history, including what the patent owner said to the office while they were trying to get the patent. And extrinsic evidence is proper when there's an ambiguity in the intrinsic evidence. The broadest reasonable interpretation, on the other hand, has been said to be at least as broad as the Phillips interpretation. So the Phillips interpretation being the bottom line, but the BRI could be a broader construction of the claims. It's the broadest reasonable meaning of the claims words in their ordinary usage as they would be understood by one of ordinary skill in the art, taking into account any definitions or that otherwise may be afforded in the written description contained in the applicant's specification. And importantly, the Federal Circuit has said that this interpretation considers the intrinsic and possibly extrinsic evidence. So when you look at between the two, it's questionable whether there is actually a practical difference. Assuming that there is a difference between the two, the question then is there any strategic impact with this change? Many parties have thought about this. Many of us have been thinking about it for a while. And it does seem that if the BRI is a broader construction, that this should change the strategy at the board. A broader scope would, in theory, encompass more prior art and allow you to make claims in the patent office that perhaps you could not make in the district court with respect to the prior art under a narrower claim construction. So now what's important is that these positions are aligned, especially for when you're filing your petition. You need to, at the outset, really have nailed down what your claim construction is going to be with respect to your non-infringement positions. And we'll see this in some later slides in one of our later lessons. I'll go through the timeline and show you why this is really important, especially in some of the jurisdictions where the case might move much faster. So is there a difference? Well, I've looked at some data, and in many cases where both tribunals ruled meaning both either the ITC or the district court and the PTAB have ruled on claim construction. The constructions have actually been the same, and they have looked at one another's construction to interpret the claims in the other jurisdiction. And actually, in one case, in the Cisco case, the board construed the claims both ways after realizing that the patent would expire during the pendency of the IPR, and actually construed the claims in the same way under both standards. But in a few cases, the constructions have diverged. One example of that is rack space hosting versus rotatable technology. And in that case, the PTAB and the district court were construing a computer display window. In the district court, they said that it had to include a graphical user interface based on the specification. And the board actually looked at the specification and found otherwise, that it did not explicitly state that there had to be a graphical user interface in the computer display window, and looked to extrinsic evidence, looked at a dictionary definition, and decided that there was a broader construction under the BRI that says a computer display window is a division of a display screen in which a set of information is displayed. So that's just one example to show the difference between the BRI and the Phillips construction. But when you actually look at these cases, the BRI construction has been decided usually using much of the case law that was applying the Phillips standard. So it's very difficult to actually separate the two and to separate the canons that would apply to either one. Also, in the cases where the constructions diverge, it's possibly due to the emphasis or the positions that are being put forward by the parties and the evidence that they point to. Perhaps there's some different prior art at issue in the patent office versus in the district court or the ITC, or the issues that are necessary to resolve the questions of infringement dictate that a finer level of construction might be needed in the district court. What does this change mean for PTAB strategy and overall in litigation strategy? It means that the board potentially can't any longer ignore what happened in the courts. At least they can't rely on the position that a different claim construction standard means that a different result is necessary for the claim construction. So it's important to understand that what the board says is not binding on the district court. What the district court says is also not binding on the board, absent, of course, a Federal Circuit affirmance of any of those decisions. But what we do have at play now is a real issue on collateral estoppel, which is an equitable principle. So what you say in one jurisdiction can certainly bite you in another jurisdiction. Certainly it is not advantageous to take an inconsistent position if you are, of course, the same party. You don't want to be arguing one thing in one place and another thing in the other. We will potentially see fewer fights over claim construction. That's the hope. That's the board's hope by instituting the same standard. There will be less justification for relitigating patents in the courts. The whole thrust behind the AIA trials was to supplant the validity analysis in the courts, and so I think that this was an attempt at harmonization in the name of streamlining these proceedings overall across the fora. Perhaps we will see fewer petitions because petitioners will find it more difficult to encompass the prior art under a narrower standard, and perhaps petitioners need to be more cautious to align their invalidity and non-infringement positions, and we'll look at that in a little bit more detail in the slides going forward. It's also possible, some have said that we would have more stays because the district court might be looking for the board's construction, knowing that it's going to come out with some construction under the same standard. But I think that's an arguable point. And with that, I'm going to pass it back to Jason to tell us a little bit more about how he believes the board will continue to change.
Sure. Thank you, Rachel. We've seen how the board has changed through some of the numbers that I talked about earlier, and then we've seen how the board is currently changing, even as recently as today or yesterday with the change to Phillips. And in the near future, we're going to see the board continue to change. And the thing that I want to focus on today is the changes that are coming to the motion to amend practice in front of the PTAB. Just a couple weeks ago, the Patent Office put out a request for comments where they detailed a dramatically different motion to amend practice. And they're seeking comments from the public by December 14th, just about a month from today. And the idea, though, is that they are going to, and they say this in the request for comments, that they are going to actually start using the new procedure in all PTAB trials probably shortly after the comment period expires. And in talking with some folks who are familiar with the plans, it sounds like it's highly likely that the changes are going to become effective mid-December, December 15th, or shortly after that. So you might be wondering, why are we talking about a request for comments? Because normally when the Patent Office makes changes that are this dramatic, they issue a notice of proposed rulemaking where they actually try to change some of their rules. They gather comments. They give the public a lot of notice about the changes that are going to happen. Here, because they are not modifying rules per se, they're just modifying some of their procedures within the scope of their statutory authority, at least in their view, it's within that scope. They think that they can make these changes just right away. And so they are asking for comments, but they are very likely to implement something that looks like what I'm about to show you in about a month from now. And the big takeaway from this is that these new procedures are actually quite involved and expensive. It's quite possible that if a motion to amend is filed in a PTAB trial that you are working on, that it could double the cost or more of the PTAB trial. And you'll see why in just a moment. But it's a significant change, and I think a lot of it is driven by the low success rate that patent owners have had so far in getting claims issued, amended claims issued during PTAB trials. And they're trying to make it somewhat easier for that to happen. And it remains to be seen whether that is actually what will end up being the result. I suspect there will be a slight uptick, at least, in granted motions to amend. But given the additional cost associated with filing the motion to amend, we may not see many patent owners trying to take this path. But one of the big changes is that the patent owner will still file a motion to amend, and the petitioner will oppose it, but the board, the PTAB, will issue a preliminary non-binding decision on the motion to amend during the trial. And if we go to the next slide here, this is a figure that's in the request for comments that the Patent Office put out. I added the red box that you see here, but it's a timeline of events that relate just to the motion to amend practice. And what happens is we already have motions to amend as a possibility in a PTAB trial, but they shorten the timeline under the new proposal so that instead of having the motion to amend be due at about the time the patent owner's response is due, the motion to amend will actually be due about a month and a half after institution. And then a month and a half after that is when the petitioner needs to file an opposition to that motion to amend. So at about the 3-month point is when the patent owner will be filing the patent owner's response, and the petitioner will be filing the opposition to the motion to amend. Then about a month later, we can see that the board will issue its preliminary decision on the motion to amend. And in that decision, it can say that it believes that there's a reasonable likelihood that the patent owner has met all the statutory and regulatory requirements for having their claims entered. And they also will assess and say in the decision whether they think that the claims would be rendered unpatentable based on the arguments the petitioner has already provided. So one outcome is that they can say that the patent owner is likely to succeed in amending their claims. The other outcome is that they could say the patent owner is not likely to succeed. And depending on which of the two outcomes they state in that decision, different things can happen. There's actually alternative paths. And if it looks like the patent owner is going to win on the motion to amend, then the petitioner actually gets to file first in response to that. But if it looks like the patent owner is not likely to win, if the claims are not likely to be entered, then the patent owner files something first, and they get to file. It's this whole new briefing schedule that's shown on the slide that's pulled up right now. They can file either a response to the preliminary decision, or they can actually file a revised motion to amend, where they perhaps add additional limitations to the claims or do something that will address any issues that the board identified in the preliminary decision on the motion to amend. And then we can see in these black dots shown on the schedule here, it's a quick succession of 1-month deadlines where the parties go back and forth with oppositions and replies and surreplies. And at least at some of those points, you're going to end up having testimonial evidence being introduced by a party through a declaration, and you'll have a deposition of that expert. Typically, it'll be an expert, and you'll have the deposition of the expert, and then you'll have, you'll have to work on the next paper that's due in this series that we see here. And so you may end up within 1 month having to prepare a substantive paper of your own, work with your own expert to prepare a declaration in support of that paper, and prepare and depose the other side's expert, all within a 1-month period. And then the next month, you get to do it all over again, but on the opposite side, where you have to defend your own expert and the other side has to do all of those steps. And so you can see it's a very compressed schedule with a lot of additional briefing that is not currently contemplated in AIA or PTAB trial proceedings. And this is where a lot of the additional cost is going to come in to play here. And so I wanted to make sure that you're aware of that. This next slide, the one that is showing now, this is also in the request for comments, which is available on the United States Patent and Trademark Office's website. So you could zoom in a little better if you decided you wanted to look very closely at this. But the top line shows the deadlines in a traditional PTAB trial, so a standard IPR. The bottom line is the motion to amend track, and you can see how many more deadlines it actually adds into the procedure. And in fact, it's more deadlines than you would even normally have in just a straight IPR. And so that's why these are going to be very time-consuming and costly events if you end up having a motion to amend or are contemplating filing a motion to amend if you're a patent owner. So what are the practical effects and what are some suggestions that we have? Well, one is submit comments to the Patent Office. You have until December 14th to do this. The request for comments provides an email address, and you can just email whatever comments you have to the Patent Office and identify the aspects that you like or dislike about this proposal, because it is not a finalized proposal yet. However, based on some of the language that's in the proposal, that they're referring to it as a pilot program. But what they mean by pilot program, and they clarify this actually explicitly in the request for comments, is they say that it's a pilot in the sense that they might modify it over time. So the sense that they're giving is that you are actually going to have this apply. They state that these new procedures will apply to all PTAB trials that are instituted after whichever date they choose to decide to start the pilot program. So it'll probably be around December 15th. They'll say, we're starting the pilot program now, and these new procedures apply to all cases that we institute today and later. So you might have a case that was filed 6 months ago before the request for comments was ever issued, and no one even had these on their radar, but those procedures are still going to apply in those cases because it's effective based on the institution date, not based on the filing date. So it's really important to have this on your radar given the potential cost and time implications that it has. So you can make your comments, but most likely they're going to proceed with something that looks very similar to this in mid-December, and they may then modify it over time, taking into account feedback from practitioners. But one thing that you should be doing if you're a patent owner is you need to really think about your potential amendments before institution, because you only have a month and a half to file your motion to amend, and there are a lot of requirements you have to meet in filing that motion to amend. So you'd really want to make sure that you know what the art looks like and that you're comfortable with your amended claims, taking advantage of the time before institution so that you're not rushed after institution. And when you get the institution decision, then you can take into account what the office has said there, and then still meet your 1.5 month deadline. If you're a petitioner, you should consider what the potential patent owner amendments might be. You know, the patent owner is going to be constrained by their written description. So you can look at other things that maybe they haven't claimed yet, but that are described in the written description, and think about whether to do your prior art searching up front before you ever file your petition. Maybe think about what are some other things that are disclosed in the patent that you think the patent owner might try to put into their claims. Maybe have the searcher, if you're using a search service, maybe have them search on those aspects as well up front, all together with the rest of the claim limitations, so that you're ready when you need to come in. If you need to oppose a motion to amend, you know, you're only going to have a month and a half to do that from when you get the motion to amend, and that can be very difficult to find a really good searcher who can thoroughly search for art on the new limitations that are being added by the patent owner. So you may want to think about that up front.
This is Rachel. I just wanted to emphasize, I think it can't be understated that they're looking for comments on these, even though it appears that they're going to move forward with this pilot program. In the BRI to Phillips change, they also had asked for comments on that rule change and received over 300 comments to the Patent Office, which actually I think is more than double the comments that they received on the AIA itself. So that's indicative of how many people are paying attention to these rule changes. And in the original rule that they had proposed, it was going to be retroactive to all cases filed, much in a similar way and perhaps even more severe than this motion to amend change is being proposed. And they took that out of the final rule in response to those comments. So the PTO is listening to what the stakeholders are saying.
Yeah, absolutely. I would encourage anyone who has suggestions on this to submit comments because it is not a done deal yet. But I do think they are going to have some form of change, and now it's just a question of which aspects are they going to leave in, which ones are they going to modify. It's a very good point, Rachel. Well, now I'd like to move on to how the Federal Circuit is changing the PTAB. The Court of Appeals for the Federal Circuit is where the appeals from the PTAB decisions go. And they have been very active in overseeing some of the things that the PTAB has been doing. Some people refer to it as policing the PTAB. They're reviewing things with a close eye. If you look at it, though, these numbers are from our AIA blog as well, and they are cumulative. You can see that every issue has been affirmed in about 74% of the cases. In about 10% of the cases, there's a mixed outcome where there are some issues affirmed and some issues that are reversed or vacated. It's only about 12.5% or so of the cases where every issue is reversed or vacated. So the most likely result when you appeal to the Court of Appeals for the Federal Circuit is that they are going to affirm what the PTAB did. But one thing that I find interesting is we've broken this data down on a quarter-by-quarter basis, and you can see that in some quarters the rate of reversing or vacating is much higher than in others, and these blue bars represent where the percentage of cases where the Federal Circuit has reversed or vacated, and we see the red line is the cumulative average. And we can see that in Q3, quarter 3 of 2018, they actually reversed or vacated in almost 25% of the cases. And one of the questions that you might have is, well, how many of those are just pure SAS remands? That with SAS, there were cases that not all of the grounds were instituted. And so there are some remands that address that, but it turns out there were only 3 instances in Q3 where it was just a pure SAS-based remand. In a lot of other cases, they reversed or vacated on an issue in the case, say a claim construction issue, and then maybe also said while you're addressing that issue, you should also address the other grounds that you didn't institute on. So it's a combined SAS and other type of issue on the remand. So even if you were to take out the 3 cases where it was only a SAS-based remand, it's still a fairly high, you're looking at a 20% or so rate of reversing or vacating the PTAB in Q3. So your chances are maybe not as dire as what the prior slide would show, but the most likely result is still that the Federal Circuit is going to affirm what the PTAB did. If we look now at some of the specific issues, we saw earlier this year that time bar determinations are now reviewable. For a long time they were not, and the en banc Federal Circuit decided that now they will look at time bar issues. The time bar that I'm referring to is that once you've been served with a complaint alleging infringement, you have 1 year to file your petition for inter partes review or other PTAB trial, and so the board had been interpreting that 1 year bar a certain way, and for a long time the PTAB had said, or rather the Federal Circuit had said that was not a reviewable issue on appeal, but now it is. And as a consequence of it being reviewable, we can see that they've now changed some of the long-standing board practice. In the interest of time, I won't get into too much of that. I will say, though, that the interesting thing to me is that the rationale of the Federal Circuit's determination that time bar decisions are now reviewable actually can extend to issues that are not time bar related. They can extend to other issues, including things like assigner estoppel, which a couple of years ago, the Federal Circuit had an assigner estoppel case. The assigner estoppel is where someone goes and tries to challenge a patent after they've assigned it to someone else. And it used to be, typically in a district court, you're not able to do that. You're not able to make that type of challenge. You're stopped from doing it, and they call that assigner estoppel. But if someone goes and challenges the patent, they assign it to someone else, and then they go and challenge it at the PTAB, the PTAB has said that's okay. You actually can assign your patent and then challenge the patent that you just assigned. And the Federal Circuit had said, no, we can't review that because that's there's a clause in the America Invents Act that says that we're just not allowed to review certain issues, and this is one of those issues in their view. Well, when they decided that time bar determinations were reviewable, it opened the door to now have lots of other issues potentially be reviewable. And just this Friday, this past Friday, we saw in a decision involving Cisco, the Federal Circuit said that assigner estoppel issues are now reviewable, and they found that assigner estoppel does not apply in the PTAB. So an assigner can assign the patent and then go challenge that patent at the PTAB. But it's just one example of how the law continues to evolve and how Federal Circuit decisions from a year or two ago are now being completely flipped on their head or at least being reevaluated under this new law. So I don't want to dwell too much. There's also been some changes in the law of standing. You'll have those slides. Basically, the idea is if you're going to appeal to the Court of Appeals for the Federal Circuit, you need to have your own standing under the United States Constitution to be able to do that. Any person is able to file an IPR petition, but you actually have to have some threat or some concrete injury potentially that you would suffer to be able to have actual standing under Article 3 of the United States Constitution to have a court hear your case. And so once you leave the Patent Office, which is an administrative agency, and go into the court system, like going to the Court of Appeals for the Federal Circuit, this standing requirement kicks in, and there have been a lot of cases lately that address which types of parties have standing, and it's an area that continues to evolve, and there are cases that are currently pending where I think we're going to start to see even more decisions on this issue. I just wanted to highlight it, not to get into the details, but to just let you know that this is another area where the Federal Circuit continues to evaluate its own jurisdiction and its ability to police certain issues at the PTAB. And so with that, I'm going to turn it over to Rachel to talk about our final topic, which is coordinating between the district court, the ITC, and the PTAB.
Thank you, Jason. I'll try to go through these slides quickly. We brushed on it earlier. I think Jason mentioned that you want to develop your positions early because of this motion to amend practice. And I also mentioned that we really want to develop our positions very early in the case because of the change from BRI to Phillips. We're no longer allowed as petitioners that wiggle room to say, well, under a broader construction, here's what I believe the claims mean, and here's how the prior art fulfills those claims. But, I might change my mind in the district court later and say that there's a narrower construction for infringement purposes. So I wanted to show you some timelines that really play this out and show why it's so important to file these IPRs as early as possible to try to get your decision before the district court, if you don't get a stay, renders their decision. It's sort of a race to the Federal Circuit at that point. And perhaps you can coordinate and align your Federal Circuit appeals if they are within a certain window of one another, but there may not be the opportunity to do that. In these faster jurisdictions like the ITC and perhaps Eastern District of Texas and perhaps Virginia and other places where the docket moves really quickly, and in some of them, such as Texas, where you are a little less likely to get a stay, and in the ITC, almost guaranteed not to get a stay of your case, it is all that much more critical to find that sweet spot to file your petition. So in the first slide, you can see the timeline for the PTAB trial on the top and the district court trial on the bottom. This is an actual example of a district court timeline in the Eastern District of Texas in a case before Judge Gilstrap. And it looks quite quick, about 21 months from the complaint filing to trial. But this is not atypical in many jurisdictions to have 21 to 24 months in the district court if there's no stay and no major roadblocks. So in this example, the petition is filed within 3 weeks of the complaint being filed. And you might ask, well, how can that happen? How can you have your position fleshed out and be ready to file an IPR at that point? Well, maybe there was some history with this particular patent owner, with the plaintiff, either with other parties and you're seeing your competitors are being attacked by this particular party, and so you might say, oh, I might be next, and start revving up your engine at that point. Or maybe there's some personal history with that party, a demand letter from that plaintiff, or licensing discussions that have gone sour and not panned out. So you may be aware of those patents. Or you may have a broader strategy of tracking and anticipating what patents might be asserted against you and have some prior art positions ready to go. In any case, this is a fairly advantageous place to be ready to file within 3 weeks. As you can see, it results in getting your final written decision before trial, and your institution decision comes before likely before your Markman briefing even begins. So as you can imagine, there are some pitfalls to this and some drawbacks to filing so early. You have a larger risk of inconsistency. As the defendant, you haven't seen any infringement contentions. You likely haven't fully thought out all of your non-infringement positions because you don't know what the plaintiff is actually asserting. You may not know exactly what claims they're asserting. You only have their complaint to go on. You maybe haven't fully thought out your invalidity contentions in the district court, and you haven't maybe had that opportunity to do the kind of discovery that you would have liked to do. But of course, this could lead to a stay if you file early before Markman briefing and before a significant portion of the discovery costs are incurred. And even if you're not stayed, the final written decision could issue before trial, and of course, potentially stay your case closer to trial if you weren't able to get the stay earlier, or be something that you can use to your strategic advantage in the district court. So what happens if you wait for the infringement contentions? Well, of course, that shifts your timeline along, so that you here are filing after you get your infringement contentions, perhaps before or just after you're filing your invalidity contentions, or rather serving your invalidity contentions in the district court. You get your institution decision sometime during the Markman briefing or shortly after, but before the district court is issuing their Markman order. And your final written decision comes perhaps just after trial. Now, this might be actually arguably a sweet spot to file your petition because you do have a more fully developed record with regard to infringement, which for a petitioner is key. And then if you're waiting closer to the 1-year deadline, which often ends up being the case simply because it's difficult to put together these petitions and these positions quickly, you run the risk of your final written decision coming well after the district court trial, and you still don't have the benefit of the Markman order when your petition is filed, and so you still have a drawback of potentially inconsistent positions. So somewhere in between the infringement contentions and the 1-year deadline would be, in my opinion, the best time to file. But as you edge closer to the 1-year deadline, you get diminishing returns on your filing, although there's still certainly advantages to filing in the PTAB. And again, in jurisdictions where you have a slower timeline, that is, it increases the advantage of filing in the PTAB. And looking at the ITC, as many of you may know, if you've had experience there, you really don't, I'm not actually aware of any stayed cases in the ITC pending a PTAB review of a patent. So you're basically guaranteed not to get a stay. And so this timeline in the ITC is extremely fast. And also there are difficulties in coordinating your position because of that with respect to claim construction. And I know we are running up on our time. I want to leave room for at least one question. So there's a couple of slides at the end here that you can review on why rushing to file an IPR presents risks in the ITC, and why on the other hand, there's a benefit to doing so. And I encourage you to look at these. And Gary, I think there's a question from the audience. We want to at least get to one.
Thank you, Rachel, and thank you, Jason, as well. We do have one question from the audience, but before we begin the question and answer portion of the event, I just want to remind everyone to please take a moment to complete our brief evaluation survey, because we continually try to improve our programs. We would appreciate your input. Now we have a short bit of time to take on questions. And as a reminder, to participate in the Q&A, just click on the Q&A button and type your question into the Q&A window and click submit. Even though we don't have too much time today to answer a lot of questions, if you do submit questions, we'll try to get back to you by email. One of us will get back to you by email to address your question. So the one question we have today is, what would be the impact of the change in claim construction standard on parallel litigation? And Jason or Rachel, do one of you want to start with a response to that question?
Sure, Gary. I'll take that one. So, you know, I really believe there isn't a practical difference necessarily between the constructions. And so I think that the practical impact is that the positions are going to have to be more fully aligned, and so there's going to have to be a little bit more careful thought. We don't have a fallback position at the PTAB where we can say that there should be a different construction later on in the district court. So I think you're just going to see an increased coordination from both petitioners and patent owners in fear of those estoppels. But the reality of what those constructions will be, I think, is more informed by the evidence that's presented by the parties. So I think that you will still see some differences in the district court when you're facing those infringement challenges, because there will be the opportunity to tell the district court that a different construction is needed to resolve a particular issue for the jury, sort of in an O2 micro type of argument that for the purposes of infringement, we need to have this extra bit of construction to clarify the construction.
Great. Thank you, Rachel. Well, I think it is now 11 o'clock in Asia, or much of Asia, and the time for our webinar is up. So I want to thank all of you for attending today's webcast, the PTAB, Lessons Learned and Practical Tips. This presentation will be available on demand in the next week. Please look for an email from us with the access link. And this concludes today's Finnegan webcast. Thanks to everyone again for participating.